Hey, welcome back. I have a wonderful guest. She's been here before, and you've probably seen her on a number of stations. Her name's Brenda Geiger. She's an estate planning attorney. She's an author, and we're so lucky to have her. Brenda, welcome to the show.
Thank you. I'm so glad to be here, Steve.
I'm glad you're here, but I want to bring out one other big thing here that's really, really important. I was just having this wonderful conversation with some clients the other day. They have about $800,000 in an IRA. And I was talking to the husband saying, hey, you know what? Which one of you two thinks going to pass away first? Because probably me, because Cindy will, she'll outlive me. That's easy. And I said, well, how would you like things to occur? He goes, well, I'd like it all to go over to Cindy. And then when Cindy passed away, go to the kids. And I said, well, what happens if she gets remarried? And he goes, I never thought about that. I said, well, what might happen is their IRA then rolls over to her new spouse. Now, then it goes to the kids. Is that what you want? He's going, well, I'm not so sure. And that's the reason why we have you here, to talk to us about that stuff.
Yeah.
And my understanding is there's other issues too, because sometimes when kids receive that inheritance, they're not quite ready for it. And just like lottery winners and people who receive lump sums, they usually go through it in a very, 70% go through in a very short period of time, like talking like 2 years, really fast, because they get red cars and they wreck them.
Yeah.
And you know what? And then there's things like, you have divorces and all sorts of things with the kids too. So, what can people do?
Well, when somebody has a collection of retirement accounts, we're talking over $250,000 or more, and they have children, I'm always talking with them about, well, how would you like this to pass down, not just to your spouse, but then to your children eventually? Because since 2003, we've had this law change that allows somebody that's not the spouse to inherit and stretch the account out. Mm-hmm. And a lot of people don't even know that that's out there and available. What it really means is that the person that inherits can take a fractional share every year and take that as what we call a required minimum distribution. It's based on a table called the single life table. And they can stretch it, and they don't have to experience the tax hit of taking the entire account all at once. So, for example, if somebody had an IRA that was a total of $800,000, and they had an 18-year-old and a 20-year-old, and their spouse is about the same age as them, when their spouse passes away, it can then go on to their children, but their children don't have to take and accelerate it. It can stay in that tax-deferred environment for a much longer period of time, until that child's 85, in fact. And each child could have their own stretch. So this is a huge advantage that a lot of people are just not even aware of, and what that can amount to when you run it through the calculator.
Well, if you think about it, you've got 30 years at 7%. That means it doubles every 10. And you're only taking out maybe 0.5% because you're in that single life table. Mm-hmm. That's very significant from an asset that you can transition off to the ones you love for decades to come.
Yeah, in fact, I've got a calculator on the homepage of my website where people can go in and calculate their own required minimum distribution for themselves. You can put in whatever rate of growth that you think is appropriate, and see what that looks like, not only for yourself, but then for your children. But creditor protection is also the other thing I think you were hitting on earlier, is that if we don't structure it in the right way to go to our kids or to grandkids, it could be blown right away. But also a creditor coming in from the outside, like, their divorcing spouse, a bankruptcy that occurs to them, they have a lawsuit against them. Any kind of number of things that could happen creditor-wise could take that money.
Well, even if you have a child that is, very not responsible when somebody asks them for money, they say, hey, I got an iceberg I'd like to sell you. They go, okay.
Yeah.
or you know what, they do have a substance abuse, and everybody that I've seen who's had a substance abuse receives money. That substance abuse gets really big.
Yeah.
And, in some cases this can kill them, and the parents really love them. They want to protect them, and they want to create something for them in the future. How do they go about doing that?
So there is a trust that is referred to as either a retirement plan trust, or I call them retirement protector trusts. Mm-hmm. And what you do is you have the beneficiaries be your children, or it could be grandchildren or anybody else. But the trust is acting as a barrier, the way that it's drafted, between the account and the person that's there to benefit. Mm-hmm. So the trustee is the person that executes the stretch on that. So that can be a third-party trustee in the case of somebody where we've got a special needs beneficiary, or we've got somebody with a drug and alcohol problem that we want to protect. Or it can be beneficiary controlled, where we let the child be in charge at a stated age, like maybe 35 or 40 or whatever age we think is appropriate for them to be able to take control of that account through the trust.
One of the big things that I see that's happening is there's a lot of trusts that were written 10, 12, 15 years ago, and they're called AB trusts.
Yes.
And tell us about the big issue with those.
Well, a lot of people that have trusts that are 5, 10, 15 years plus older, maybe they haven't revisited those trusts. And they don't realize that they have this ticking time bomb in their trust. And what it means is if you have forced A-B provisions that the trust will split into an A and a B after the death of the first spouse, whatever is funded, moved over, the decedent's portion is moved over to the bypass trust, or the B trust as they call it, that's going to be subject to gain at the death of the second spouse. So when the eventual beneficiaries then inherit the property, they might have a capital gains on their hands if the assets that were funded are assets of the type that are subject to gain. So a lot of people don't realize in a forced AB situation, there's no choice. We have to split it into an A and a B outside of going to court and petitioning to see if we can dissolve that.
And if the estate's not $5.5 or $5.4 million, they might not even need that AB, or they don't need that AB trust, and they just could be hurting themselves or their heirs.
A Q-tip might be a better answer if they're looking to protect the decedent's half, you know, maybe from a later remarriage of the surviving spouse. And if they have an estate that's maybe between 5 and 11 million, maybe a Clayton election might be a better option because we have more flexibility.
So basically what we're saying here is the A is the above ground person, the B is the below ground person, and they're forced to put money in that below ground person trust, and when that above ground person passes away, this portion is taxable.
Could be.
Could be, and it could create some problems. Now, what do people need to do if they have one of these old trusts? They should be contacting somebody like yourself, a lawyer, to get involved and understand what's going on. What would your best advice be?
I would get a review done. So if you have a good relationship with your current attorney, go back to them. If you don't, find an attorney that you trust to take a look at it and see if they'll write you an opinion letter to let you know what they think should happen.
Now, could you revisit, what we talked about this earlier, the retirement protector trust, correct? Mm-hmm. Okay. Revisit why somebody would be looking at that.
So especially if you have children or grandchildren, you may want to turn that account that, let's say it's worth $500,000, you don't realize that by giving that to your children eventually after the death of you and your spouse, that could be several $1,000,000 because of the lifetime value of that stretch, being able to be in that tax-deferred IRA or 401k, 403b, other qualified account. That can go on and on. So a lot of people just don't realize that we can not only do that, the stretch, but also creditor protect it by the way that we have it go through a separate trust called a retirement plan trust or retirement protector trust.
I do want to bring something out. I have one client that at the age of 22, it went through the trust, the stretch, and he figured out as long as the account averages 7%, he'll receive $600,000 by the time he was 22 and the time he is 90, and then his kids will get it after that. And that happened for all 11 of his nieces, nephews, and brothers and sisters. And I think that's a wonderful option to have because the coolest thing about it is I see my grandfather's name every single month.
Yeah.
So.
Yeah, it's really cool.
Brenda, thank you so much for being part of our show today.
Thank you.
And hopefully you'll come back soon.
Yeah, I would love to.
Now, if you would like to get more information on how to get your trust reviewed for if you have an AB trust or a retirement protector trust, you can go to the Silver-Haired Tsunami website or go to the Geiger Law Office website. Stick with us. We'll be right back.